Hi everyone, my name is Sierra Ferrari and today I will be reporting my evaluation of Priceline's terms and conditions while recommending changes that would make the agreement clearer, fairer, and more likely to be enforced. The original assignment refers to Part 1, Sections A through F. However, the current agreement available through Priceline's website uses numbered sections. Because of this, the version I provided, I evaluated the current introduction and Sections 2 through 6. I also reviewed Section 10 because it controls how disputes are resolved. My evaluation addresses 4 questions. First, does Priceline's agreement create a valid contract? Second, should someone be bound merely by visiting the website, or should Priceline require the person to click I agree? Third, can a customer sue Priceline? And finally, what changes should Priceline make? My overall finding is that Priceline's terms and conditions can create a valid contract when a customer knowingly completes a booking. However, Priceline's attempt to bind every person who merely accesses the website is less certain. Priceline should require affirmative acceptance and make important provisions, particularly its arbitration clause, easier to see and understand. Finding 1 was contract validity. A valid contract generally requires an offer, acceptance, consideration, parties with legal capacity, and a lawful purpose. Priceline offers customers access to travel information, booking technology, customer assistance, and travel-related services. A customer may accept that offer by completing a booking. Consideration is present because Priceline provides access to its platform and booking services, while the customer provides payment, information, and promises to follow the agreement. The agreement also addresses legal capacity. Section 2 states that a user must be at least 18 years old and have authority to enter a contract. The agreement has a lawful purpose because it involves legitimate travel booking services. These elements support the conclusion that a contract is formed when a customer knowingly makes a purchase. However, the existence of a written agreement does not automatically mean every provision will be enforceable against every user. Priceline must still demonstrate that the customer received reasonable notice and agreed to the terms. The most uncertain language appears in Priceline's introduction. Priceline states that a person agrees to the terms and privacy policy by accessing its website, contacting its call center, making a booking, or modifying a service. This language treats ordinary website access as contractual acceptance. In my opinion, completing a booking provides stronger evidence of acceptance than merely viewing the website. Someone could visit Priceline to compare hotel prices without realizing that Priceline considers that action an agreement to mandatory arbitration, liability limitations, and other significant restrictions. Finding 2 was user acceptance. Online agreements are often classified as browse wrap or click wrap. In a browse wrap arrangement, the terms are provided through a hyperlink. Often at the bottom of a web page, the company argues that continued use of the website indicates acceptance. In a click wrap arrangement, the user must affirmatively check a box or click a button stating that the user agrees. Courts are generally more likely to enforce an online agreement when the website gives conspicuous notice and requires an action clearly demonstrating assent. In Wynn v. Barnes & Noble, the Ninth Circuit found that an inconspicuous link to terms at the bottom of a website did not provide sufficient notice. In Berman v. Freedom Financial Network, the Ninth Circuit explained that a company must provide reasonably conspicuous notice that the user must take an action that unambiguously communicates assent. By comparison, Meyer v. Uber Technologies shows that an online agreement may be enforced when the screen clearly tells users that continuing will indicate agreement to linked terms. Based on these authorities, Priceline should require affirmative agreement when a customer creates an account or completes a booking. I recommend an unchecked box beside a statement that says, I have read and agree to Priceline's terms and conditions, including the mandatory arbitration and class action waiver. The terms and arbitration provisions should be directly linked. The customer should not be able to complete the transaction without checking the box. This approach would benefit both parties. Customers would receive clearer notice, while Priceline would obtain stronger evidence as an agreement was formed. My third finding was customer disputes. Priceline's dispute provisions appear in Section 10. Under those provisions, most customers cannot immediately bring an ordinary lawsuit against Priceline. The agreement first requires the customer and Priceline to participate in an informal dispute resolution process. The customer must provide written notice describing the dispute and request relief. This information process generally lasts 60 days. If the dispute is not resolved, an agreement generally requires binding individual arbitration. Arbitration uses a private arbitrator instead of a judge or jury. Priceline's terms also include a jury trial waiver and a class action waiver. Therefore, it would not be completely accurate to say that customers cannot bring legal claims. Instead, Priceline limits the forum and procedures available for resolving those claims. Several exceptions apply. Qualifying claims may be brought in a small claims court. Certain claims involving intellectual property rights may also proceed in court. Priceline also provides a third-day period during which a customer may opt out of arbitration by sending the required written notice. If a dispute is not subject to arbitration, Priceline's terms generally require it to proceed in state or federal court in Connecticut. Small claims cases may be filed in the county where the customer resides. The arbitration agreement may be enforceable if Priceline can demonstrate adequate notice and acceptance. However, if a customer never received conspicuous notice or took an action clearly indicating agreement, the customer could challenge whether an arbitration contact was ever formed. Recommended changes. My first recommendation is to replace reliance on browser wrap with affirmative click wrap acceptance during account registration and checkout. Second, Priceline should provide a short and conspicuous summary of its arbitration clause, class action waiver, jury waiver, cancellation restrictions, refund rules, and liability limitations. Customers should see these provisions before paying, not only after opening a lengthy agreement. Third, Priceline should improve its amendment process. Its introduction states that Priceline may update the terms by posting a revised version, and that continued use indicates acceptance. Eric Goldman's analysis of Harris versus Blockbuster demonstrates the risk associated with this approach. In that case, Blockbuster reserved broad authority to modify its agreement at any time. The court concluded that its arbitration provision was illusory and unenforceable. Priceline's current arbitration section offers more protection because it promises notice of future material changes to the arbitration agreement. Nevertheless, Priceline's general amendment provision still expects customers to monitor the website. The Electronic Frontier Foundation's TOS BAC project also demonstrates the importance of transparency. TOS BAC allows users to compare older and newer terms and identify what a company added or removed. Priceline should maintain an accessible archive, identify the effective date of each version, and provide a summary of material changes. Fourth, Priceline should email customers a dated copy of the agreement governing each booking. Material amendments should not apply retroactively, and major changes should require renewed acceptance. Fifth, Priceline should explain more clearly whether it or a third-party travel supplier is responsible for each party of a transaction. The current agreement frequently directs customers to airlines, hotels, rental car companies, and other suppliers. Customers should know whether Priceline is acting as the seller, booking agent, payment processor, or referral service. Finally, Priceline should revise the provisions governing its artificial intelligence assistant, Penny. Priceline warns that Penny may provide inaccurate information and requires customers to verify its response. It also broadly disclaims liability for errors resulting from reliance on Penny. Customers should verify important travel details. However, Priceline should remain responsible when its own system confirms a booking, cancellation, payment, or travel change, and a customer reasonably relies on that confirmation. Priceline should also provide clear consent choices before recording voice interactions and explain how those recordings will be stored and used. My final assessment is that Priceline's terms and conditions can form a valid contract, particularly when a customer knowingly completes a booking. However, enforceability depends on adequate notice and meaningful acceptance. Priceline's attempt to treat ordinary website access as acceptance creates avoidable uncertainty. Priceline should require customers to firmly agree, highlight its arbitration and class action provisions, provide direct notice of material amendments, preserve earlier versions, and clearly explain its relationship with travel suppliers. It should also accept reasonable responsibility for transactions completed through its AI assistant. These recommendations would not prevent Priceline from protecting its business interests. They would create a clearer agreement for customers while giving Priceline stronger evidence that its terms were knowingly accepted. This concludes my evaluation report.